15 minutes here, so I want to introduce Brian Schneider from Bright MLS. He's going to give us sort of an update on where things stand with the MLS and industry overall. And then we're going to take a break for about 15 minutes and come back for our panel discussion, which will be, I think, very entertaining. We've got some hot seats up here. So, all right. Brian?
Let me see if I can try it from here.
Yeah.
Give me a hand in the back. Can you hear me in the back like this?
No, you need the mic.
All right. All right. Am I going to get feedback if I stand here with the mic? No. That's better? All right. Let's see if we can do that. Good point. All right. So I'm Brian Schneider. I'm a partner with the law firm Arent Fox Schiff. I do work with Bright MLS. They're my favorite client. But I work with a lot of MLSs around the country and trade associations around the country. It's great to be here this morning. I feel like I'm in good company, that all of you actually wanted to be here on a beautiful day inside listening to two lawyers speak. I wouldn't do that to see me speak, so thank you for doing it for whatever reason. Maybe the food was really good. I want to talk a little bit about what are we seeing on the ground, right? The marketplace has shifted mid-August, right? All the rules changed. The NAR settlement came into effect, and it's all in the rearview mirror, right? Everything is hunky-dory, and we're all good, right? Okay, not exactly right. So let's take a step back and just remind ourselves, where were we? March of this year. It was only March that the settlement happened. March of this year, we were looking at almost 30 class actions around the country, naming hundreds of real estate brokerages, many of which were less than 20 agents. A lot of people don't realize that. Total bankruptcy forcing activity across the country. I was representing MLSs and Associations in Texas, Nevada, and we had brokerages in those cases that were unable to afford a lawyer, let alone a settlement. So that's where we were in March. Settlement comes around from NAR to buy out all of the cases. Whatever you think of the settlement, that is a remarkable outcome. That they were able to buy out cases to which other people were defendants and people who weren't even named get released in any of the cases. That is remarkable. That is an incredibly creative solution, and I have to give them credit. Whatever you think of the actual outcome of the case, that's darn good, and it's good for everyone in the room. But the key is that in order to actually be part of the settlement, a lot of people don't remember this, it's not just new MLS rules. There are 5 rules in the settlement agreement that every single realtor must comply with for the next 7 years, or you are risking your entire brokerage being unreleased from the settlement agreement and subject to a lawsuit. And if you don't know what those 5 rules are, or if you haven't been training your agents on what those 5 rules are, get to business on that. Because if you want to make sure that your business is covered by the settlement, like most of your businesses were for free, you've got to have those 5 rules in every one of your training documents. And the 5 rules are all pretty straightforward. You've all read about them. You got to have a buyer agreement before you go on a tour. It doesn't mean the buyer has to pay something. It means you got to have an agreement. You can agree that the buyer pays nothing, but you've got to have an agreement. If your seller is going to make an offer of compensation, it has to be agreed in writing in advance. You cannot do it blanket on your email unless every single one of your clients has written authorization to do it. You must disclose to every one of your clients, buyers and sellers, that commissions are negotiable. You cannot represent that your services are free. You can describe how you get paid, but you can't just say, hey, this is free to you, blanket statement. It's an arbitrary line, and they drew it. And lastly, consumer disclosure. And this is going to be my theme for this morning. You cannot filter, restrict, limit what you share with your client based on what the seller or the seller's broker is going to pay the other side. You have to be open with your clients. That is the biggest hurdle, I think, for a lot of people who are still not comfortable with the deal, is that transparency with your client. You're telling me I have to show my client every single property, even if the other side isn't going to pay anything? You don't have to take them on a tour if your client doesn't want to, but you have to tell them about the property. You have to say to them, look, here's the 10 properties that fit your bill. Here's what's being offered by the other side. Some of them are offering nothing. Here's what that means. Do you want to see all 10 properties? This is what advising means. You know, you're all used to it. You're all smart people. But tell your friends, because it's the people who aren't in this room who are not interested in hearing lawyers talk for 2 hours in the morning that aren't complying with this stuff today. So what does this ultimately mean? It means that consumer transparency is the name of the game for all of you. And that is my message to ask you to echo going forward. What we are already seeing on the ground in the last 3 weeks since the rules have changed, and certainly in the 2 or 3 months as people were thinking about how to apply the rules, how do we not enhance consumer transparency? We were hearing so many comments. How do I not have to have this conversation with my client? How do I not disclose this in an open way? The answer is you can't. The answer is you must have these open conversations with your clients. And the key is around compensation. You know, we're seeing on the ground in the last few weeks a real mix of practices. Some listing agents and brokers have said, let's continue to make a blanket offer. I think it makes sense for my home. I think it makes sense for this market. Great. Many are not. Many are saying, that doesn't make any sense. Why would I do that? Let the buyer come to me, tell me how much they need, and we'll decide whether it's covered or not if I want to sell my house. Right? That's a perfectly rational economic decision. And if you're not advising your client, buyer and seller, about that economic decision, are you being the most transparent and best value to your clients? I have to ask that, because that's the question that state AGs are going to start asking and class plaintiffs are going to start asking. They are highly focused as they think about what their next steps are, is who's hiding the ball, who's not playing by the new rules, and how are they trying to keep up compensation, keep up their rates through other means. So that brings us to forms, right? We're seeing a lot of debate around the use of standardized forms. Different states, different localities have different forms. Some are absolutely better than others. If you aren't thinking critically about whether you think the form that you are using works for you, your business, and your clients, please do. Please don't use the form off the shelf simply because it's off the shelf. If the form works for you, great. But if it is creating a compensation arrangement that you don't want to use as a business, or that you feel might create legal risk for you, which some of the forms may, revisit it. There's no reason why you can't. But just because we're all used to the notion that we can't revise the form doesn't mean you actually can't revise the form. I'd say most of the brokerages that I have talked to, a lot of which are in this room, are saying, yeah, we're creating our own form, or we're choosing to use this totally different form that we got from someone else in the business because it makes sense. Now, does it make sense to have a common purchase offer, a common ALTA? Of course, absolutely. But buyer representation, listing representation agreements, make it your own. That's your value. I saw a question in the back.
Yeah, what are the implications of that on the E&O coverage?
What's the implications of that on E&O coverage? Talk with your E&O provider.
I have not heard a single E&O provider say you must use a state form. So I've heard people
People say they think my E&O provider requires that, but I will be shocked
if anyone can actually demonstrate that.
if you modify the state form. You better have a lawyer say yes, that works. But that's not a huge hurdle. Yeah, some of us are expensive, but it doesn't take a lot of work to look at one line that you've edited and say, yeah, that still works on law.
Do you like the GDAR form?
I'm not going to comment on the GCAR form. I'll be serious. So do you think that any of the forms that are being provided today are transparent to the consumer around your relationship and are not trying to maintain the system of compensation that was used pre-August 17th?
You seem to suggest that the current form is not correct.
So I think there are lots of forms in this market that still are problematic, and I think there are some that are much better than others. I will say the Northern Virginia Association form is one of the best in the country. Let me elaborate on that, because I think it's helpful to understand why do I think that. Two things. It's readable, right? A real consumer can read it. It is not in all caps. It is not in illegible language. It is readable. Two, and this is the most important, it does not suggest a standard mechanism for paying your broker. And it does not suggest a standard mechanism for paying the other side's broker. It allows options. It completely acknowledges that this is between you and your client. Here's a form that you can use to choose how you negotiate with your client over how you get paid and how they want to pay the other side. If the form doesn't do that, what exactly is it trying to accomplish? Whose interest is it in? And that is where, I think there's huge risk. There was a string of posts on LinkedIn, let's see, today's Thursday, Tuesday, by class action lawyers who have been involved in these cases going after these forms, saying this is exactly the kind of case that we are going to bring up next year once there's another year worth of damages. This isn't just me making it up, right? They're out there, they are watching, and this is easy money for them, right? If your office gets a demand letter from one of these lawyers and says, hey, we won last year, here's what we're coming after you for again for doing the same thing, are you really going to not settle? Yeah.
Irregardless of how you feel about NAR, I feel like there's so much optimism, frankly. I've been in the state business for 32 years. In 1 2 week time, we went from we're being sued, here's the deal to we're going to appeal this, don't worry, then to, okay, here are the new rules because we didn't appeal after all. I'm asking, and I asked my broker this, why do I need to be a member of NAR because I don't feel like paying them anymore for the service? And I'm told they own the MLSs in our local market, as well as ancillary services such as lock boxes that are involved in wood car, machine car, and every car. And I don't understand if that is a solution, then what is? And why do we even need to be dealing with our local MLS when we don't even get to show what our compensation is? Why do we need MLS? We have our
Yeah.
own information.
Okay,
Why
so-
is why is MLS selling our information to ancillary websites to sell back to us as leads? When are we going to wake up?
Yep.
Thank
Okay.
you.
Great points. Four great points. Three of them are wrong. One of them is factual, and that needs to be dealt with. First, you do not need to be a member of NAR to be a member of almost any MLS in the country. However, if you are not a member of NAR, you are not released in the settlement, and you're subject to lawsuit. That's your choice. Two, lockboxes are accessible to non-realtor members of the MLS, as is the MLS. You can be a non-realtor member of almost any MLS in the country these days, certainly Bright MLS. Your third point was, what's the value of the MLS? Without being a shill for the MLS, I think the value is still incredible for the MLS because you have no way to market homes in as inexpensive a way as through the MLS, period. Full stop. Yeah, the ability to market a home to 100,000 subscribers and then thousands of websites with a click of a button and a $500 a year fee, no one's going to do that. And if you try to do it through CoStar or Zillow directly, welcome to $5,000 a year fees per listing, just like they do for commercial. Good luck. Your fourth point is a great one. How do we stop paying to get our leads back from sites that we're giving our listings to? This is a hole that the industry has dug itself in the last 20 years, in part because of a settlement with the Justice Department 20 years ago that the Justice Department blessed, and in order to get out of a hole that the industry was in for the prior 20 years. And that issue is my top priority right now. As I think about strategy for my MLS clients, as I think about legal strategy, but also business strategy, figuring out how do we give agents and brokers more flexibility around how do you manage your listing information so that you can put it on the places you want and not have to put it on places that are selling you leads back. I'd say the easiest answer to that right now is that Bright MLS, like most MLSs in the country, you can put it in the system and check internet no for that listing. That means it's only available in the system. That means that if you want to put it on certain websites, you can, but Bright will not. That is an option today. It has been an option for 10 years. And people don't realize it and are underutilizing it. You don't want to have it out there to pay for leads back? Well, it can be. I don't know who said that. It was it beneficial for clients? It can be if you want to market it on certain sites. Yes. So don't let it go out to 1,000 sites. If you want to put it on X, Y, and Z site, you can choose how to do it as long as you're talking with your client about it. Yes, absolutely. There's great data actually about the value of selling this property. There's an economic analysis about the difference between, for home sellers, marketing widely on every website, marketing only within the MLS, and marketing as private exclusives. And from an economic perspective, the studies that have happened so far have shown that within the MLS can be just as effective as selling as putting it out to websites. It's the private exclusives that home sellers may be losing time and money on. No. Zero. Well, okay, actually that's not fair. They charge a $500 fee for every vendor that wants to set up a website as an administrative fee. Most MLSs do something like that. But no, there's no of the data, there's no referral back, there's no leads. No. And no MLS does that.
So the case is talking about an MLS that says, to my knowledge, a seller allowing the listing to be on the internet.
Yep.
I think everybody in this room thought that meant the seller's allowing it to be published. You're saying that that link is not going to go.
Right, you can unclick that and say no internet. It's only available in the system to subscribers in the system.
You know that? That the seller's agreeing is not going to any other way.
You absolutely can do that. As long as, I mean, you better make sure your seller knows that because they're going to call you the next day and say, why the hell is my house not on Zillow? Right? But start having that conversation, folks, because, there are good reasons for your client not to want to have their house on every single website. There are perfectly valid reasons for that, and in some ways it can amplify the value of you marketing the property in the community. But yes, absolutely. Check the internet, no discussion. Now, with your client's authority. All right, I want to keep moving because I know we want to get to the panel discussion and break after all that coffee. So what are we looking for ahead? All right, there's kind of four things that I'm looking out for looking ahead. First is November 26th. So November 26th is the hearing in Missouri where the federal judge is or isn't going to approve the NAR settlement. Before then, the DOJ is going to file a brief that everyone is going to freak out about. Be prepared. Don't freak out. They're going to say the following. Offers of compensation are antithetical to consumers, antithetical to competition. No one should be making blanket offers of compensation. That's what they're going to say. And people are going to freak out about it. And the reality is there are some real fair housing challenges to the new market regime. I've heard from lots of agents, brokers, advocacy organizations saying, you have to just remember everyone is at least implicitly biased, if not explicitly biased. We all are. And the reality is if you get two offers in and one person is not from your club or not who doesn't look like you, there's a risk of bias, whether it's the agent that doesn't look like you or their client. That is the fear with not having blanket offers and having to negotiate each deal. People may discriminate. We as an industry have to just call it what it is. We have to stop it. We have to stop it when we see it. We have to say that this is not acceptable, but that is part of the fear of the new regime. So the DOJ is going to be attacking the offer of compensation. Expect that. The judge is almost certainly going to approve the settlement. There are still class actions out there, though. There are buyer-side class actions. There are class actions against the now probably about 40 brokers that were not included in the settlement. So the cases are not over. We're still watching them. The good news is they really shouldn't, long story, they should not affect the vast majority of any of us because they've become so narrow. The bad news is they're going to affect some people. They're going to affect some companies, and they are as well. The other issue that we're looking out for, and I sort of touched on it a little bit, this is where I'll close on some great high notes. What should you be afraid of in the next year? So, look, the DOJ has their eye on your industry. I've had almost weekly calls with different attorneys at the Justice Department because there are now multiple teams in California, in DC, Department that are now, and they are using every lever they can to tweak how you do business. What they're basically doing is saying, we're going to threaten to sue you if you don't do this. And what do? Are you not going to do the thing they're asking? Are you going to accept that the Justice Department is going to sue you? Pretty rare company, MLS, broker, associations that's going to take that risk. And so they are using this opportunity as hard as they can to twist that knife and change how we act. And what they're trying to support, their mission is total consumer transparency. They want everything out from under the rug. They want the consumer power to be complete, and they don't think agents are needed. They have said that. They think most buyers could get away without an agent. You just need a lawyer or a title company. Most sellers could probably do this as well, given the internet age. They don't have a clue. They don't have a clue. But that is their perspective. And so as we think about how do we frame the Justice Department's perspective, you've got to sort of keep in mind that they have a warped view of your value. I think the other thing that we are looking out for, that I am very concerned about, is control over, and I say your, meaning brokers, agents, intellectual property, and your customers. So, one of the real values of the MLS is that they are here to serve you and protect your intellectual property and protect your customer relationships. So the MLS does not take your customer relationship with your seller or with your buyer and feed that out to anyone, or say that that's our relationship. There are big companies, public companies that own large portals that do not take that view. We are already seeing super aggressive intellectual property demands by one of them. When folks are putting photos into their system says that they own that photo now. So do you like having rights over the photos you take or your photographer takes for the homes and the offices that you represent? Bear in mind that as soon as you enter into their system, they own it. They can do with it what they want, and they can tell you what you can't do with it. Yeah.
When you say put it into their system,
Yep.
this is a system that Bright feeds into, and the photos feed into their system. That's putting it in their system?
Perfect question. No. And the reason is because they are if Bright gives data to them, it's on our terms. We set the license rights. And that's a big part of my job, is figuring out how do we manage those license rights. And to your point over here, I'm trying to figure out how do we give you even more flexibility to limit those license rights going to those third parties. Yeah, again. Yeah.
So if you were to go back to your thing about unchecking the box and putting it on the whatever
Yeah.
site that might start with a Z that you were talking about, that would be giving the picture to them, correct? If you unchecked the box and said, I'm going to put it directly on
Yeah.
X, Y, and Z.
Yeah, just to reframe and rephrase the question. So yeah, if you put your Bright, you're using the Bright system or any other MLS, and you uncheck the internet distribution. So now you, as the broker, you get to control where you have that on the internet. If it's on your site, great, you own all the rights, right? You get to control that. But if you then go into the listing entry system at CoStar, Zillow, or the other ones, they are saying, okay, thanks, we now own this. Yeah. I love that you're reading agreements like that. Thank you. Thank you. Yes, not enough people are. They're just signing them, and they don't realize what rights they're giving away. You've given away the rights. Yep, that's a great example. Go ahead. If you take the picture, you sitting down there.
Yeah, pivoting just a little bit. The blanket offer of compensation question. It feels like that's still in the site. Like right now, things have been playing out the last few weeks, right? Buyer agents calling seller agents and saying, "Hey, how much are they compensating?" And we get to say that. But is that not a blanket offer? I mean, it's no longer a public blanket offer.
Mm-hmm.
And I'm just curious. Like, it feels like that might be like the next whatever.
So, as long as your seller has authorized you to make a blanket offer to anybody, yeah, anybody who calls, tell them that we'll pay up to X.
That authorization already existed. The issue is the private portal aspect of like the right.
Okay. So, well, there's two pieces, right? So, most forms that I've ever seen did not specifically authorize you to make a blanket offer to the other side. Most forms. Now they have to, and they do now. But the question is, how are you making that offer now? The literal logistic of how are you now communicating that offer? If you're putting it on your email, like in your signature line, I don't know how you're doing that because not all of your clients have authorized you to offer the same amount every time. Maybe they have. Maybe you've covered your bases that way. I'm skeptical, but maybe you have. But if you're just doing it by text or email on a one-off basis upon request, there's nothing unlawful about that. The risk of that is extremely, extremely, extremely low. Where I do see risk is where people are setting up Google Docs or websites to say, hey, put all your offers of compensation in here, list the address, your contact information, and the offer of compensation so we can like more easily look that up. That is fodder for another class action.
Like if you create the ability to search by compensation, this is the problem.
If you create the ability to search by compensation or just to search among brokerages for what they're offering, yes, that is a huge problem. It's a huge risk. That's what you're going to get. That's what you're going to get sued over.
You don't think you can email out to agents, hey, here's my new listing, and I'm offering X amount?
I think you could do that if that's what you want to do. If your seller has authorized you to do it, absolutely. Yes, if your seller has said make a blanket offer of X percent and you send 1,000 emails out, nothing wrong with it.
But what's really going to happen is you're with, let's say, A company, and I'm going to give you 3, and you're white, and I'm going to give you 2.5, and you're female, and I'm going to give you 2.
Yeah. No, I mean, it's that kind of discrimination that will happen. Someone will do that. Someone will do that, and no one's going to know, and it's terrible, and we have to call it what it is. I agree. Yeah. You had a question there.
Yeah, I called the compliance department and all that. Maybe you weren't aware. And right as this, the new program was in place, a number of agents are doing their email blast.
Yeah.
Come see my property. Not only are they saying we'll compensate, they're actually listing 2.5%, 3%. And what I got back was it's not an MLS, so that's legit.
Yeah.
Do you see that as the next shoe to fall in terms of the DOJ?
No.
suing?
Well, so the DOJ's position is you shouldn't be making blanket offers of compensation. I don't think they have a legal ground to actually make that stick. So to his question, and similar to yours, if you want to send it in an email, as long as your client authorized it, send it out to 1 million people. Here's what we're offering. Put it on a billboard. Put it on your business card. Sure.
And you're going to defend it.
Yeah. I think I saw a hand up over here. Yeah. Well, sorry, I feel like there's some code in that question, and I'm not. Yeah. You're talking about private exclusives, right? You're talking about private exclusives, pocket listings? Yeah. Yeah. So there's kind of three flavors to why data doesn't get in, assuming an right? There's pocket listings, and I solved that in my view. So best in the country. No one else has done what Bright does. You have to put a pocket listing, an office exclusive. You have to put it in the system. It doesn't get shared in the system, but the data's there, and at closing, it's still in the data. So you've captured the data as best you can. Someone has an option if they really don't think it's in their client's interest. I challenge whether that's the case, to use the MLS for distribution, at least to subscribers or to the internet. Flavor one. Flavor two, a broker is involved on the buyer side. Maybe it's a FSBO, maybe it's a non-MLS participant on the selling side. The buyer side can put it in as a comp. That is still going on, and I think, to your point, there should be more incentive to do that so we get the data. And then the third, this is where it's controversial, is let's just say you managed it off MLS in some manner. Should you be able to put it in at closing in the system so we capture the data? The problem with that is you're then creating the database and get everyone the data and access to the cooperative data that you're supposed to be getting. On the flip side, are you excluding some data? That's a contentious issue. If you have an interesting solution, I would love to hear it, over coffee. But that's one we grapple with. Yeah. I agree. Yeah, but that's probably the scenario that could get captured better. Yeah. I saw one more hand. I think we're running out of time, right? Are we? Yeah. Okay. One more from someone who hasn't asked. Did you? Yeah. I don't think I heard from you. Yeah. So the question was, in 30 days when things start to settle and we see at the closing, in the closing fields, where concessions are we creating our own problems? It's a great question. So we started off with the closing concession fields being much more specific, including a specific line item for payments to the buyer's broker. That's not there anymore for exactly the reason you said. So what we did was we looked at the ALTA and we tried to line up buckets of funds at closing from the buckets that are in the ALTA. So A, it's easier for your office to enter post-closing because you can look at the ALTA, get the data right in. And B, we don't want to create an antitrust problem for you. And being able to have a specific item to track how much the buyer broker was getting paid by the seller creates an antitrust problem. So there's no longer a specific line item. What there is an other. So you've got very detailed line items for finance related, home improvement and inspection related, and other. Our theory is that that other category will most likely be buyer broker compensation, other incentives that are relatively small, and that will give you the ability to advise your clients around what's the trend in the market without being able to know the specific amount. That's the idea. So trying to give you the best data you can as your clients that will be available nowhere else, but is not going to create an antitrust problem for you. That's a great way to end. Thanks, everybody.